Aloha, this is Professor Porter. We're talking about the Federal Rules of Evidence and specifically Article 4 under the policy rules 407 to 411. And this is specifically Rule 411 having to do with liability insurance. And just imagine we have these policy rules in there for a certain reason because there's some kind of behavior we're trying to deter or some kind of behavior we're trying to encourage out in society, so therefore we don't let it become part of trial. That's the deal with liability insurance. Generally, out in town, out in the world, we want people to have liability insurance. We want them to have insurance when they drive around in their cars. We want them to have liability insurance for when they own a business and people are walking through in case someone slips and falls and gets hurt. We want people to have insurance. And the fact that they have the insurance or the fact that they do not have insurance, we really don't want as part of trial. And we don't want to leave it up to, for reasons we've discussed, to relevance, and we don't want to leave it up to a 403 balancing test where it's up to the judge and the discretion on that day. So like the other policy rules, a specific policy rule having to do with insurance, simple one sentence, evidence that a person was or was not insured against liability is not admissible to prove that they're at fault here, that they acted negligently or they're otherwise acted wrongfully. So just think about that. It might make sense if you're the proponent at trial, you might want to put on some evidence. You're the plaintiff, you're suing the defendant's shop where there was a slip and fall and your client was hurt. You might want to say, yeah, you know what? We want to put on evidence that they have liability insurance. Well, let's let these jurors know that there's some money out there that they can grant us some money and the store won't be paying. You can't do it for that reason. You can't introduce it for that reason. Similarly, let's just say you got a motorist out there and there's a hit and run and there's a car accident and we eventually track them down and it lands in a lawsuit and you're the proponent and you want to say, I want to put on evidence that this person was not insured against liability because I want to communicate that message to the to the jury. Both of them are going to the fact that they are at fault. They're the ones that acted negligently or otherwise wrongfully. So that's the bad purpose. You can't introduce that they had or did not have liability insurance for the purpose of saying, so therefore, use that as one more brick, use that as one more piece of evidence that they're at fault here, that they acted negligently, that they acted wrongfully, that it goes to liability in some way. And in 411, unlike some of the other rules that we've seen, like 409, offer to pay medical expenses, then they get into, well, that's the bad purpose. But the rule makers tell us there's a few good purposes. The court may admit this evidence for another purpose, such as ownership, the witness's bias, proving agency, proving control. So if essentially if I fall on a sidewalk out in front of a couple different businesses and they're all denying ownership, if I show that this person had liability insurance that covers this sidewalk, I'm introducing liability insurance, but not for the purpose of proving that they acted negligently, not for the purpose that they acted otherwise wrongfully, to prove that they own it or they control it or there's some kind of agency relationship with the area. So you can think about it. That's the good purpose built in the second sentence of this rule. The bad purpose is put in the top. So just think about it. If you are the opponent and you are the one objecting, the proponent is standing up there about to introduce evidence of liability insurance. You're the one charged with not only thinking about relevance, all evidence has to be relevant. You're thinking about 403, that you're balancing anything that's unfair or suffers from the dangers of 403 and has low probative value such that you can urge the court to exclude it based on its discretion. And you have these specific policy rules. Once you see the words liability insurance, you're thinking Rule 411, and you're like, if I'm the opponent, I'm objecting under 411 in addition to maybe some other objections, and I'm saying they are trying to introduce the thing that's called out in this rule. They're trying to introduce evidence that this person had or did not have liability insurance. For why? For the bad purpose. Of course they are. What is the proponent trying to do? What is the proponent trying to prove? They're trying to do it for the bad purpose, to show that we're at fault, to show that we acted negligently or otherwise wrongfully. And they're not allowed to do that. That's what the first sentence of 411 says. You can picture that proponent making their way to sidebar, outside of the ears of the jury, two hands up in the air. No, 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 no. Not the bad purpose here. I'm offering it for some other purpose, some good purpose that's actually set out in the second half of the rule. I'm introducing this as it goes to ownership. I'm introducing this as it goes to control. I'm introducing this just so it establishes the witness's bias. It doesn't have to do with the ultimate issues of whether they acted negligently or otherwise wrongfully. That's not why I'm doing it here. Not the bad purpose, good purpose. That's what the proponent's going to say. And just think, if the trial judge comes in under any of these rules where there's an argument that here, opponent says bad purpose, proponent says good purpose, and they ultimately say, yeah, you know what, overruled on the objection, I'm going to allow it in. just remember limiting instructions under Rule 105. Anytime something comes in for one purpose and it's not to be considered by the jury for another purpose, that opponent should be saying, Your Honor, at this time, right now while we're introducing the evidence, can you offer a 105 limiting instruction where you explain to them, ladies and gentlemen of the jury, you can consider the following evidence that'll be before you about the slip and fall and about the liability insurance only for the purpose of ownership or control, parentheses, good purpose. You should not consider it as to who was wrong here or who might have acted negligently or otherwise wrongfully, bad purpose. So you actually instruct the jury at that time to use it as the rule intended it.